to help, subsidize the golf course to be viable for years to come seemed like a great idea. And we progressed with asking for a subdivision, land use change, as you know, and we presented, I think, a building that's, I know that some in this audience have disagreed, but it's a great looking building in front of a metal building that we didn't really like that was built back in 1994. So this we thought was a win-win for the community.
Okay. And based on your recollection and your experience, is any portion of the golf course property been posted with regards to tonight's hearing?
Not that I'm aware of.
Okay. And has the golf club received any notice in the mail in advance of this hearing?
No.
Okay. Based on your understanding of the latest draft, all of these different transfers that you've just described historically that has happened, would those be able to be effectuated today under the new ordinance?
No.
No, because there are changes from the most restrictive use.
That's correct.
Okay. That's all I have for Mr. Swisher. I have some brief information. I want to submit a report from John Trant that, at the suggestion of your council, we've included in our binder as Exhibit 17. I'm not going to read it. It's fairly lengthy, but he raises a number of concerns that I'm just going to summarize for you with regards to the latest draft that is before you. Particularly our concern that community or private membership outdoor recreational facilities, that land use is singled out for different treatment, such that the property with that land use can't be changed to another land use permitted in the SD district without going through what amounts to a rezoning application, reviewed and approved or denied at the sole discretion of the Board of Supervisors. In particular, we're concerned about the disparate treatment. I'm basically isolating this use such that you can't seek any other changes, and only this use is the one that would have to seek approval for any change in use. No other land uses would have to seek that change, and if that doesn't amount to disparate treatment, I don't know what is. That's a classic example. In addition, this creation of a process by which adjacent property owners can somehow participate, approve, and consent, but then revoke their consent at any time, creates a process that's just simply not contemplated under the MPC. There's no requirements regarding this process about factors or conditions to be met. The proposed amendment is unclear as to the forum, as to this presentation with regards to adjacent property owners. There's no direction as to whether a meeting has to be private or made in public, and there's a complete lack of clarity with regards to this process. But even if 100% were to agree to a waiver of the board's review of the change in a land use or land use category, the adjacent landowners may revoke their consent at any time. And what this does, the prospect of such a revocation would leave any type of property sterile and undevelopable, because that kind of uncertainty, no bank would finance any development. There wouldn't be any possibility to proceed with regards to that property. That type of process is just unrealistic in the market, but more importantly also constitutes a de facto zoning by referendum. In Pennsylvania, the zoning authority that's delegated to townships under your statute, under the MPC, is delegated to this board. You don't have the authority to delegate it to anybody else. And to say that somehow some approvals have to be conditioned upon or voted on by a neighboring property owner is just runs afoul of the MPC as well as your constitutional authority. Finally, there's another provision that the Board of Supervisors is not obligated to provide a change in land use or category or land use, which essentially creates a fourth type of land use. The MPC authorizes municipalities to designate a particular land use within a zoning district as one of three types: use by right, conditional use, or special exception. Only conditional uses are reviewed by the board, and those reviews are supposed to be based on objective criteria. But the board doesn't have a sole discretion to deny a conditional use under the MPC. But this proposed amendment seemingly creates a fourth use category that essentially grants the Board of Supervisors authority to review the change of a permitted use. So by creating this process, you're giving yourself authority that you simply don't have under the NPC. And to have any type of unfettered discretion without any objective criteria by which a use is evaluated is further contrary to all the provisions of the NPC. Briefly, we have some charts that Mr. Trant had provided, which outlines what the current impact is with regards to these changes. Exhibit 18, 19, and 20 in your binder. 18 shows what happens if there's a proposed change of land use. Again, the community or private membership of the recreational facilities at the top, the most restrictive. The only way it can be changed is to go through the rezoning process. With regards to anybody else, any other use, because they're viewed at the same level of severity, they're not required any type of application or submission to change land use within their category. Or alternatively, you have this process that, well, if you get 100% of the adjacent property owners, the board then can, in its sole discretion, waive its requirements. But as we outlined before, that type of process is not only not contemplated by the MPC, but involves this impermissible zoning by referendum. With regards to changes in land use category under Exhibit 19, again, residential's at the top, then commercial, then industrial. If there's any change upwards from commercial to residential, it sounds like the property owner's application would be evaluated by the Board of Supervisors, but pursuant to undefined conditional use factors. There's nothing set forth in your ordinance, no objective criteria. If someone in a residential category wants to go to a less restrictive category, coming down the ladder to, say, a commercial use, you have the rezoning again. And again, if you have 100% of adjacent property owners, you can waive in your sole discretion. Again, a process that is simply outside the purview and contemplation of the MPC. All of these types of changes requiring this rezoning process with regards to our property means instead of having 52 potential uses, we are limited to 1. And to say you have options, you can get a rezoning or you can seek the consent of your property owners are false options because it doesn't give you any defined criteria to meet or any expectations, and you are essentially locking this property into a use ad infinitum. So, just briefly touching on the conclusions that Mr. Trant had, starting on page 14. He believes that he notes that the proposed amendment restricts the availability of land uses on properties in a manner that is contrary to your statement of intent for the special development district, and furthermore singles out this particular property by restricting it to 1 permitted use. Because of this, all other uses are not available. You're freezing this use into perpetual time. This is antithetical not only to the intent of the ordinance, but also would be contrary to law. The second observation is, as I alluded to, that this ordinance amendment would create an approval process that's not authorized by the MPC. There is no objective criteria regarding any type of conditional use that could be evaluated. At most, it seems to be a conditional use process to see whether or not there is going to be an actual, conditional use is the actual process as opposed to the actual use itself, and not focusing on the individual use. Use in and of itself is the conditional use here, according to the amendment, and there's no criteria by which a use can be judged. And that's contrary to Pennsylvania law, where you have to have objective criteria for conditional use. Another point was this accomplishes a rezoning of the golf course property through an improper use of a text amendment, reducing the number of available uses from 55 to 1. By slashing the number of these available uses, you've circumvented the MPC with required notice, etc., process and property posting for rezoning of the property. And this rezoning by this amendment is contrary to the MPC because you failed to follow those procedures. In addition, the land use amendment restricts the permitted land uses of a particular tract of land, but doesn't restrict similarly situated properties. If you're singling out the golf course property here, and everyone else is not required to go through the same requirements, even though there is no objective criteria or any reason as to why to treat this property any different. The only reason is because it appears to be, we want to keep this as a golf course. The topography and the physical character is no different from any of the other properties that are surrounding. There is just no justification for this disparate treatment. Furthermore, consistent with the stated intent of the SD district, there should be flexibility to provide illustrative site plan revisions based on the changes needed to adjust to changing market conditions. Each individual permitted conditional use in the SD district would then be evaluated based on objective standards and criteria. But this amendment eliminates all such flexibility regarding this property, but retaining it for all other properties. As previously noted, we also believe this amendment grants improperly to adjacent property owners the ability to determine the township's land use review and approval process. Depending on the circumstances, adjacent property owners determine what approval process is used for use changes. And zoning by referendum is not permitted in Pennsylvania. An outright freezing of the property's use because adjacent property owners expect to rely on the fact that continued use will continue is inconsistent with good planning practice and an improper and illegal delegation of land use decisions. We also noted here, Mr. Trant noted that the proposed amendment creates the ability of the Board of Supervisors to waive the requirements of the Unified Development Ordinance as approved by the surrounding property owners, despite the lack of authority by the MTC to do so. So in this new process that you've created, whereby you seek 100% of the property owners' consent, at that point, the Board of Supervisors, according to your ordinance, can waive all requirements of the ordinance. You're basically giving yourself the powers to grant variances and waivers of ordinance requirements. You're not able to do that under the MPC. That type of procedure is simply not contemplated. Finally, this amendment's creating a land use scheme that treats one particular use different from all other permitted uses in the SD district without any basis or evidence to justify it. The golf course is the only property here that would have to seek approval for a change of use under this amendment. No other land uses would have to. And this clearly is a targeting of this particular property to the detriment of this owner that is not required of other similar situated property owners. In sum, we don't believe that this comports with the MPC or sound community planning principles. I believe it's arbitrary and capricious, particularly with regards to the lack of any justification for this disparate treatment. The township has already acknowledged multiple times that the goal here was to stop change of the use of the property. But to do it in this fashion, in such a blatant manner to target this property, means that this is essentially a spot zoning. And spot zonings are illegal in Pennsylvania. There's no other use so limited, no other property so limited. There are no physical characteristics which distinguishes property from any other property. And there's no evidence that it can't be developed in accordance with other categories and standards here because of physical characteristics. There's no sound basis for this disparate treatment. And so this particular amendment as drafted is clearly unconstitutional. So with that, we would respectfully suggest that this amendment draft is not of a form and substance that should be voted on by this board, that this needs to be vetted and carefully drafted to recognize the rights of every property owner, not to the detriment of one in particular. And I would respectfully request that you consider all the points we've raised here tonight. Thank you.